Well, to start off with, if I was to give you recommendations, what you need and what would help, I would start off by try to find the file or all the documentation that the lawyer that represented you provided you after closing. Okay. Now, most attorneys will need what's referred to as an abstract of title. Now, in our office, we do not send the abstract of title to the prospective or to the buyers. We either hold them or we send them to the abstract company to hold on to. But some of the attorneys back a long time ago, 5-10 years ago, would send the abstracts right to their clients after closing, which I think is a mistake because they don't even know what these documents are. So I would take the time to look in your safety deposit box or your file cabinet just to see if you have an abstract of title. And what an abstract of title is, it's a document very similar looking to this. And it opens just like this, okay? And it's a 60-year search of your property. It's a record of all the people who purchased your property, sold your property, any liens or encumbrances that may have been on your property. And it helps us because we don't have to go back 60 years if you already have it. And you'll save quite a bit of money if you can locate that document. And if you can't, don't worry about it, because oftentimes we can locate it because it'll be usually held in an abstract company, so we can get a hold of it. Now, the next thing I would suggest you getting is a copy of your deed. Now, we don't need a copy of your deed to close a transaction, but the only reason why I would ask you to get a copy of your deed is when you meet with your agent, you want to make sure that the name you put on the contract matches the name on the deed. We want to find out several weeks into the process that either your attorney made a mistake in writing the wrong name on the deed, which happens more often than I'd like to admit, not with our office, but with other offices, or there may be something peculiar about the way you acquired title, and it would be easier for us to know that information. And I'll give you an example, is like a lot of times the kids may get the property from their parents, and the parents may retain life use. Sometimes the parents have put it into a trust and given it to you. Sometimes you may have acquired a property with certain restrictions, and you may not even know these restrictions existed until you obtain a copy of your deed. So that would be helpful. The last thing I would suggest you doing is calling the town that you live in and asking them for a copy of all the certificates of compliance that are on file with the town with respect to your property. Now, if you have certain improvements on your property that either you did yourself or you purchased the house that way, you should ask the town, well, I happen to have a pool or a deck or whatever, a gazebo. You have to ask that question. Do we have, or are there certificates of compliance on file with the town dealing with these improvements? Now, the town should be able to tell you these things, and you'll need to know this information so when you sell the house, you have full disclosure to the prospective purchasers as to the possibility that either one, you have them, or two, you don't. And you can deal with those issues early on in the process and not find out several weeks later that you don't have them, which can lead to some issues as far as the buyer's ability to cancel the transaction. Other than those three things, your attorney should be able to get you everything else necessary to close your transaction.